Hello students, today we will be discussing the topic of right to life vis-a-vis sustainable development. Introducing the topic, environment is everything around us, including both living and non-living things such as soil, water, animals, plants which adapt themselves to their surroundings. It is nature's gift that helps in nourishing life on earth. The environment plays an important role in the existence of life on the planet Earth. The word environment is derived from the French word environ, which means surroundings. According to Environment Protection Act 1986, Section 2A defines the term environment, which means environment includes water, air and land, and interrelation which exists among and between water, air and land and human being, other living creatures, plants, microorganisms and property. Although the conservation of environment need not be constituted as non-intervention, the industrial production process cannot be permitted to go unhindered to pollute the environment. According to Patton, we cannot have an absolute right to an unspoiled environment, for modern industry must at least in some areas destroy rural beauty. The best that the law can do is to curb the worst excess of industrialization by town planning. Noise and pollution are two of the greatest offenders. Pollution, however, affects air, water, natural growth and health of the humanity. It is true that every industrial activity causes some kind of deterioration in environment quality, and we cannot claim so much purity of environment as can be expected in a pre-industrial society. But at present, we are facing the problem of fast deterioration of environmental quality due to development activities. As development is essential to fulfill increasing human needs, a change in lifestyle that entails going back to age of pre-industrial revolution is unconceivable. Thus, consequential ill effects of development activities visibly show up in challenges of environmental pollution, ecological imbalances and climatic modifications. The sheer necessity of environmental law signifies a conflict between development and environmental protection. The need to balance the values of development and environment therefore becomes eminent. Meaning of sustainable development. The concept of sustainable development has surfaced globally. The principle is most important principle of environmental law, but the concept is difficult to define in few words. The literal meaning of sustainable development is to find way to development which will improve everyone's quality of life without damaging the environment and without creating problems for future generations or transferring such problems to people in other parts of the world. Brundtland report states that sustainable development is the development that meets the need of the present without compromising the ability of the future generations to meet their own needs, also referred as intergenerational equity principle (IEP). Sustainable development essentially means development in harmony with environment. The World Conservation Union 1971 defined sustainable development as a characteristic of state that can be maintained indefinitely and increasing capacity to meet human needs and improve the quality of human life is development. This implies that for coexisting there should be a proper balance between environment and development so that neither of them are affected adversely. Although the term means different thing to different people, the following 8 principles are fundamental to the concept. Number 1, intergenerational equity. Number 2, use and conservation of natural resources. Number 3, environmental protection. Number 4, the precautionary principle. Number 5, the polluter pay principle. Number 6, obligation to assist and cooperate. Number 7, eradication of poverty. And number 8, financial assistance to the developing countries. Historical background of sustainable development. The term sustainable development was used for the first time in 1972 during CoL-Right Declaration on Environment and Development. The concept was backed up globally at Stockholm Conference in 1972. Since then, sustainable development has been a vital part of all conferences, declarations, and other events and activities related to environment. The world reiterated its commitment towards sustainable development at World Summit on Sustainable Development, Johannesburg, South Africa in 2002. Here, they declared to assume a collective responsibility to strengthen the three interdependent pillars of sustainable development, that is, economic development, social development, and environmental protection. Constitution of India and environment protection. Though no specific constitutional provision is present focusing on environmental protection, Part 4A, consisting only one article, was incorporated by Constitution 42nd Amendment Act of 1976, imposing a fundamental duty under Article 51A subclause G upon every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion, including forest creatures. Another provision for protection of ecology and environment pollution is contained in Article 48A of the Constitution, states that the state is to take measures to protect and improve the environment and to safeguard the wildlife and forest of the country. But as we know that the provision differs from the fundamental rights contained in Part 3 of the Constitution, and it is settled position that the directive principles of the state policy are not enforceable like the fundamental rights, as the idea of the welfare state can only be achieved if state endeavor to implement them with a high sense of moral duty. In recent decades, on a number of occasions, the Apex Court has granted the status of fundamental rights to many directive principles of state policy, and the Apex Court, in accordance with Article 48A, directed the central and state governments along with various local bodies and boards to take appropriate measures for the prevention and control of pollution of water. The Apex Court since the 80s has shown broader approach while deciding the writ petition under Article 32 by relaxing the traditional rules of locus standi. It is settled now that under Article 226 before the High Court and under Article 32 before the Apex Court, public interest litigation would be maintained pertaining to the matter of environment protection. As per requirement of judicial approach in India, the public interest litigation is entertainable in areas of water or air pollution or conservation of forest or cruelty to animal. The judiciary is the guardian of the Constitution. They aren't supposed to sit as mum spectators and turn their eyes and be unconcerned for the issues of society. The powers of the Apex Court are of extensive amplitude, and the court should adopt activist approach to issue directives to the state to implement environmental measures against pollution and check activities causing ecological disturbances to protect the constitutional rights, human rights, and environmental rights of the people or citizens. The judicial activism for environmental protection is praiseworthy. Right to life and sustainable development. In Subhash Kumar versus State of Bihar, the Supreme Court held that pollution-free water and air is a critical part of right to live under Article 21 of the Constitution. In Rural Litigation and Entitlement Kendra, RLEK versus State of UP, the court held that right to live in a pollution-free environment is a fundamental human right and ordered the closure of some limestone quarries on the ground that there were serious deficiencies concerning safety and hazards in them. A committee was appointed by the court to examine some limestone quarries. On examination by the committee, certain limestone quarries were observed to cause a lot of pollution, thereby affecting the environment adversely. due to which they were ordered to close. In the case of MC Mehta versus Union of India, also called as Shri Ram Food and Fertilizer case, the Apex Court introduced the principle of absolute liability, which directed that the companies responsible for manufacturing hazardous and lethal chemicals and gases which posed a danger to health and well-being of the workers and people residing in its neighborhood are to make sure all essential safety measures were in place before reopening the plant. The plant had leakage of chlorine gas which caused the death of one person, posing danger to health and well-being and made breathing difficult for the workers and locally residing population. Ignorance and mismanagement in maintenance and operations of the chlorine plant caused this accident, which was presented in the court through a public interest litigation. The management was ordered to deposit a sum of rupees 20 lakhs as a way of security for payment of compensation claim of the victim of the oleum gas leakage with the registrar of the court. In addition, a bank guarantee for a sum of 15 lakh was also ordered to be deposited, which shall be uncashed in case of chlorine gas escaping within a period of 3 years from the date of the judgment, resulting in death or injury of any workman or any person living in the nearby area. On compliance with orders of the court, the plant was allowed to function partially. In MC Mehta versus Union of India, famously known as Ganga pollution case, the Apex Court ordered the closure of tanneries at judgment near Kanpur which were polluting the river Ganga. A social worker brought attention of the Apex Court to this matter through a public interest litigation. The court stated that notwithstanding the comprehensive provisions contained in Water Act 1974 and Environment Protection Act 1986, no effective steps were taken by the government to prevent the grave public nuisance caused by the tanneries at Kanpur. In these circumstances, it was held that court was entitled to order the closure of tanneries unless treatment plants were set up. In MC Mehta versus Union of India, PIL was filed against Ganga Water Pollution Board, claiming that although Parliament and state legislature have passed numerous laws imposing duties on the central and state boards constituted under the Water Prevention and Control of Pollution Act 1974 and the municipalities under UP Nagar Mahapalika, but they have just remained on papers and no appropriate action has been taken in this regard. This forced the court to issue relevant directions and ruled that the petitioner, even though not a riparian owner living on the river side, was entitled to relocate the court for the implementation of various statutory provisions which enforce duties on the municipal and other authorities. He is a man who is passionate in protecting the lives of the people who make use of Ganga water. The problem caused by pollution of the river Ganga is a public nuisance and it is widespread, which in turn affects the lives of plenty of people, and therefore any person can take proceedings to stop it as distinct from the community at large. Consequently, the court directed that Kanpur Nagar Mahapalika will submit its proposal for effective prevention and control of water pollution within 6 months to the board constituted under the Water Prevention and Control of Pollution Act 1974. It additionally directed that the Mahapalika to relocate dairies to the outskirts of the city and arrange for removal of debris from the canal to prevent access to the Ganga river, to lay sewerage line wherever it is not constructed, to construct public latrines and urinals for the use of poor people free of charge, to ensure that the bodies or half of the burnt bodies are not dumped into the Ganga river, and to take action against the pollution industry. Additional license to establish new industries should only be issued to those who practice adequate condition for the treatment of commercial industrial pollution. The court further held that the above guidelines apply mutalis mutandis to all other Mahapalikas and municipalities with jurisdiction over the areas where Ganga river flows. In an important decision in Indian Council for Enviro-Legal Action versus Union of India, that if by action of any private corporate bodies a person's fundamental right to live in pollution-free environment is violated, the court would not accept the argument that it is not stated within the meaning of Article 12, and therefore action cannot be taken against it as per the orders of the apex court. If the court finds that the government or authorities concerned have not taken the necessary action required from them by law, and this has resulted in violation of the right to life of the citizens, it will be the responsibility of the court to intervene. In this case, the environmental organization filed a written petition before the apex court under Article 32 complaining about the dilemma of the people dwelling near the plant industry in India and requesting for suitable corrective actions. Whereas the fact was that an industrial complex was built in Bichare village, Udaipur district, Rajasthan, and the plaintiff established their own chemical factories there. Some of these industries were synthesizing chemicals like oleum and monophosphate. Neither did the defendant obtain the required license for the synthesis of these chemicals, nor did they install appropriate waste disposal equipment. This resulted in pollution in the wells, making the water unfit for human use. The outcome was disastrous, as fatal disease spread in the villages and surrounding areas. The local people revolted, all of which led to the suspension of H-acid production, and eventually the factories were shut down. However, the after effects of their deeds persisted and continued to cause disease and death in the village. The apex court requested the National Environmental Engineering Research Institute to study and report the condition of the village. In the technical aspect of report, it was observed that 720 tons of sludge out of the original 2440 tons was still there. To hide the sludge from inspection teams, the accused has dispersed it all over the areas and concealed it with mud. The sludge wasn't removed despite the court's order. The apex court stated that the writ was maintainable and directed the government and authorities concerned to perform their statutory duties under various acts, that is, Environment Protection Act 1986, Water Prevention and Control of Pollution Act 1974 as amended up to date, Air Prevention and Control of Pollution Act 1981 and Hazardous Waste Management and Handling Rules 1989. This is a social action litigation for securing socio-economic to the villagers whose right to life, as reported in numerous reports by the expert, was intruded and violated by the respondent as is established. The apex court ruled that the respondent to be held accountable for impairment to the soil, to underground water and to village at large. Regarding the determination of the cost of remedial measures, the court ruled that the central government to have the ability to decide the cost of the remedial measures to be taken. The accused is liable to pay the cost of remedial measures according to polluter pay principle, which states that the responsibility for repairing damages is that of offending industry. In MC Mehta versus Union of India case, the apex court demanded that hazardous industries operating in Delhi to close down with effect from 30th November 1996 and relocate as they are posing a threat to the ecology. The court directed that they are reallocated lands to the National Capital Region as provided in the Master Plan for Delhi. Essential directives for safeguarding the rights and benefits of the employed workmen were also given by the court. Similarly, in Council for Enviro-Legal Action versus Union of India, relevant rules and regulations were issued to implement and enforce laws for protection of environment. A registered voluntary organization for environmental protection filed petition as a PIL complaining about the ecological degradation in coastal areas in India. They contended that no government issued regulations were being enforced in that area. In fact, these regulations were bluntly violated as environment and ecology damaging industries were being set up in that area. The apex court ruled that the matter should be referred to the relevant state apex court, which will issue the necessary orders or directives. Vellore Citizens Welfare Forum filed a writ petition in form of PIL, drew the court's attention to the pollution caused by the massive emission of untreated skin-based contaminants and other industries in the province of Tamil Nadu. This case is known as Vellore Citizen Welfare Forum versus Union of India. It was argued that tyranny offered to the wealthy who could not be treated in the agricultural sector. This led to the pollution of groundwater and damaged the psychochemical soil, made it unsuitable for agricultural use. It was stated by the apex court that such industries, though are of vital importance to the country's development, but they cannot be allowed to destroy the ecology, degrade the environment and pose a health hazard, and cannot be permitted to continue their operation unless they set up pollution control devices. On behalf of the court, Justice Kuldeep Singh delivered the judgment and stated that while such industries are of vital importance for the country's progress as they generate foreign exchange and provides employment avenues, but having regard to pollution caused by him, principle of sustainable development has to be adopted as a balancing concept between ecology and development. His lordship held that the precautionary principle and the polluter pay principles are an essential element of sustainable development and should be applied. Correction of the degraded environment is part of sustainable development process, and as a result, the polluter is responsible for paying for individual patient and the cost of rehabilitating the degraded environment. The apex court has ruled that the precautions and the polluter pay policy have been adopted as part of state law. Article 21 of the Constitution guarantees protection of life and personal liberty. Article 47, Article 48A and Article 51A subclause G form the constitutional mandate to protect and improve the environment. Apart from the constitutional mandate, there are many laws in this regard that place a responsibility on government to protect the environment and pollution. The court ordered the factories to shut down unless pollution control devices were installed. The court also held that all the tanneries required the approval of the board concerned to continue operating from December 15, 1996. A fine of Rs 10,000 is imposed on each industry. The money will be donated to the Environmental Protection Fund and will be used to compensate the affected people and restore the damaged environment. Pollution charges will be reimbursed as arrears of land interest. Skins that fail to value the amount will also be sued in court. The court recommended the establishment of a special bench to be called the Green Bench of the Madras High Court to deal with environmental cases. In case of S. Jagannath versus Union of India, the petitioner was the chairman of Gram Swaraj Movement, which is a voluntary organization for promotion of the fragile social sector. He filed a letter under Article 32 in form of civil proceedings seeking the coastal zone regulation notification to be enforced in order to prohibit framing the low density fish species in fragile coastal area, restriction on the use of waste wetland prawns, and the constitution of National Coastal Management Authority to protect marine life and coastal areas. The apex court stated that setting up of shrimp cultural farm inside the prohibited areas and in ecology fragile coastal areas have ill effect on environment and coastal ecology and economics, and therefore they cannot be permitted to operate. Shrimp culture industry is neither directly related to waterfront nor directly needing foreshore facility and cannot be allowed to be set up anywhere in the coastal regulation zone under CZRN. Justice Kuldeep Singh who delivered the judgment of the court, said that the sea coast and the beaches are the gift of nature to the mankind. The aesthetic quality and recreational utility of the said areas has to be maintained. Any activity which has effect of degrading the environment cannot be permitted. Apart from the right of the fishermen and farmers living in the coastal areas to run their living by way of fishing and farming cannot be denied to them. The earning on the sale of coastal aquaculture product is way less than the damage caused to ecology and economics by the aquaculture farming. The traditional type of shrimp farming is environmentally supportive and pollution free as stated by the court, but the advanced technological type of farming using chemical to yield more produce creates pollution and degrading effects on the environment and ecology, and therefore such type of shrimp farming cannot be permitted. Due to critical environmental damage in Aravali Hill, the apex court refused to lift the ban on mining. Also, a safer route was taken and a monitoring committee was established which would report each mining case, and accordingly the permit would be granted. The monitoring committee was given 3 months to file the report, and the apex court clearly mentioned that the permit would be granted only with compliance of stringent condition and sustainable development. The protection of Aravali Hills is of utmost importance. The court said that environment protection and development are not nemesis. By applying stringent safeguard, development is possible on principle of sustainable development without degradation of environment. The court further stated that in a scenario where there is a conflict between irreparable damage to the environment and irreparable damage to economic interest, environment protection must proceed over economic interest. According to precautionary principle, anticipatory action should be taken to prevent harm. Direct evidence of the harm to the environment is not mandatory. Anticipatory action may also be taken on reasonable suspicion. Conclusion: it is submitted that a lot has been done by the Supreme Court of India for the protection, conservation and well-being of environment, yet implementation gaps are observed. These gaps over time have become the scapegoats of the defaulter, wherein they easily wriggle out and are actually not identified and punished by the judicial system. So, it is recommended that penal provision must have harsher punishment. Participation at individual level for the protection of environment is of utmost importance. It is the time that citizens become the true ambassadors of environment by keeping a keen eye on various activities which happen in and around them, which are detrimental to environmental health. Hence, mass awareness had to be created. All have to work in coordination, that is, the people and the system as a one single unit. It is only when such a cooperation and joint responsibility exists, judiciary will also be able to close these gaps in its implementation of penal laws. I hope the lecture is useful for you. Thank you and have a nice day.